Welcome to part 2 of my information dump on the TikTok ban. I have done all of the legal research. I have read all 3 briefs and read cases that are relevant, and I'm going to tell you all about it. We're going to go part by part. This is a multi-part series. Today we're going to talk about the levels of scrutiny that are required on First Amendment challenges. For First Amendment challenges in the United States, there are 3 levels of scrutiny. The highest one is strict scrutiny, next is intermediate scrutiny, and the lowest one is rational basis. Nobody in this case is arguing that rational basis applies. It's either going to be strict or intermediate scrutiny. I expect that in front of the United States Supreme Court, when that argument happens, there is going to be a lot of debate about which one of these standards applies. So let's get into it. Strict scrutiny applies when content-based or viewpoint-based laws restrict speech. For a law to survive a strict scrutiny analysis, there must be a compelling government interest that the government is advancing by that law, and the law must be narrowly tailored by the least restrictive means. For example, in 2004, the United States Supreme Court overturned the COPA, the Child Online Protection Act. That law said that it was illegal to put anything on the internet for commercial purposes that would be harmful to minors. They were targeting corn. The court found that there was a compelling government interest in protecting minors on the internet, but that this law was not the least restrictive means to do so. The court found that there was filtering and blocking available that would achieve the same result but not restrict all the speech. So the United States Supreme Court found that entire law to be unconstitutional. One level down is intermediate scrutiny. Intermediate scrutiny applies when it's a content-neutral regulation of speech. Intermediate scrutiny requires that the government show an important or substantial government interest. That's something less than compelling, which is what strict scrutiny requires. The restriction on speech for that important or substantial government interest must be narrowly tailored. There is one level down, which is the rational basis test, but nobody's arguing that that applies in this particular case. I do anticipate that at the oral argument, there's going to be a lot of discussion about whether intermediate scrutiny or strict scrutiny should apply, because based on the briefs, the parties do not agree on that. There's only been 3 times in the history of the United States that restrictions on speech have survived a strict scrutiny test. So obviously, TikTok, ByteDance, and the creators want the strict scrutiny test to be applied. The first one was in 1992. It was the Burson case. That's the case that says that there's a 100-foot restricted zone around polling locations where you cannot campaign or hand out campaign material. The court found that there was a compelling government interest in preventing bribery, violence, intimidation of voters. The court also found that that was a minor geographic limitation and that the restriction on speech was worth it. The next one was in 2010, Holder v. the Humanitarian Law Project. In that case, there was a new law that said it was illegal to provide material support to a foreign terrorist organization. That law was upheld. The court found that there was a compelling government interest in not aiding terrorists, that it did not suppress speech, it only suppressed material support, and that material support was not speech, that there was a narrowly drawn and important distinction between the two written within the law. Finally, in 2015, the court upheld a restriction on speech in the case of Williams-Yulee v. Florida. In that case, Florida passed a restriction on personal solicitations for donations from judicial candidates. So that's people who wanted to be a judge who were asking for money for their race. The court held that there was a compelling government interest in maintaining confidence in the judiciary. We don't want to think that our judges are corrupt. The court also held that it was not that bad of a restriction on speech because it applied evenly to all judicial candidates, no matter what their views or opinions were. Keep following for more. I have a few more videos where I need to lay the groundwork for First Amendment law, and then we're going to go into the briefs and what this oral argument is going to look like.